The Law Matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. This program's been created to educate, inform, and help you with law matters because the law matters. Understand the law better, and you're in a better position to help yourself, your family, and your business. We provide information and resources that'll help you determine whether or not you might in fact be able to do or handle some issues yourself. If you do need additional outside counsel, at least you'll be in a better position to manage it, hopefully help your counsel, and of course the goal is to achieve the best results possible. You'll save time, money, and hopefully receive better results. We welcome and thank, as always, the Bazar Grasso Law Firm in East Providence, who continually donate their time and their expertise on the various topics that we'll tackle. So today we would like to welcome again David Bazar.
Hi, Deb.
So today, bail reform, bail basics. Starting out for a second to say to you that recently there was a police officer in New York who was shot in the head during a gun battle with a drug-selling addict who had just been returned to the streets by a judge who ordered him into a drug treatment program instead of going to prison. So we know that incarceration is costly. We know that prisons are overcrowded. You know that bail can be costly, but sometimes it's even denied or just not available to someone. Rehabilitation is noble. It's less costly. Sometimes it works. Sometimes it can't. So as we discuss these issues today, this is not about an indictment or to say that the judge was irresponsible in what he did, or that diversion drug problems are wrong, or that there was even entirely misguided justice system. This program really right now is intended to help give you an overview about bail. Hopefully you'll never have to deal with it, but what you should know, and also what's happening right now that is critical and is inclined from East Coast to West to have people undergo bail reform. So, David, if somebody ends up being arrested, there's an issue about processing, booking, and bail. What's that about? Give us a tutorial.
So, don't confuse bail with sentencing after someone's committed a crime. I've been accused and convicted of committing the crime.
Okay.
Bail is just when you're accused of a crime. So you still have the presumption of innocence. So the question is, what can the judge do in determining how to set bail, and what is the purpose of bail? So bail is set at the start of a case to make sure of a few things, one of which is to ensure that the defendant is going to show up for his court dates, and two, to protect the community at large. So when you're charged with a crime, you're usually arrested and brought to the police station. Depending on what the crime is, the police can, in Rhode Island for instance, determine whether or not to call a bail commissioner to the police station, who could set bail before you're even arraigned, which is the first court date when the charges are processed against you. So if it's a misdemeanor, generally the police might call a bail commissioner who would come in, charge a fee, and set bail at that point in time, and then you would go to the arraignment where the judge would reset bail. So remember, the first thing is, what is bail for? The bail is for protecting the community and making sure that you appear for your court dates.
When you're arrested and they start this thing that they call processing, as the TV shows refer to it, what goes on? What happens? Is that when they just take your name, address, serial number, and fingerprints or something?
And picture.
And picture.
Right. So you're brought to the station and you're processed. So the processing is all the information that needs to go into the paperwork for the police to bring the charges to court. So your fingerprints are taken, your mugshot is taken, you're put through the process of what information they need to get from you that you may or may not provide, because remember, you don't have to provide any information to the police. And so then all of that stuff is done, and you're put into the holding cell at the police station. And if it's a serious crime, they're going to hold you there until they take you to court, usually the next day, or if it's over a weekend, the following Monday, so that you can face the judge, and the charges are then read to you, and the judge gets to look at what the charges are and the factors that go into setting bail. So if it's a misdemeanor, like I said, generally they may call a bail commissioner in Rhode Island who can come in and has authority to set the bond, the bail. If you're held until you go to court, you're charged with a crime in court, the arraignment is done where the judge gives you your rights and tells you what you can and cannot do, and then he sets the bail. So we would look at that point in time to the factors that might go into a judge setting bail. The seriousness of the crime, I think, is first and foremost. Someone who's charged with shoplifting, a $10 item from a store, a misdemeanor, isn't going to be treated the same as someone who is obviously charged with a capital crime, murder or whatever. So the judge looks at the seriousness of the crime. Then the judge will ask the prosecutor, what is the criminal background of the person, the defendant, because that might factor into whether or not there are flight risk. There are other issues that can be brought up from the different types of charges that may have been in your past, that type of thing. And again, the type of crime to determine what other factors might go into the bail other than money. Because setting bail isn't just about money, but they can also set other conditions on your bail. So let's talk about the different types of money bails and then the conditions. The money that can be set can be, if it's a misdemeanor or go ahead.
Tell our viewers again what kinds of things end up being misdemeanors.
Okay, so misdemeanors are crimes where there's a fine of less than, depending on the state, a certain amount.
1,500, 2,000.
Yeah, again, 10,000, whatever. Yeah, it depends state by state.
Okay.
And in Rhode Island, for example, imprisonment of less than a year. So if it's a misdemeanor, which is a crime that doesn't reach the level of a felony, theft under a certain amount, domestic assault, assaults in general, where there's not serious bodily injury, that type of thing, misdemeanors. So in setting bail on a misdemeanor for someone who's never been in trouble before, has ties to the community, a job, family, that type of thing, usually will get set on what's called personal recognizance, which is your promise to come back. You don't put up any money, you sign a sheet, there are conditions on that, usually keep the peace and be of good behavior, appear at all your court dates, don't leave the state perhaps, could be part of the condition unless you work out of state and then you want a permission to leave the state. Those are the types of general conditions on a personal recognizance. So the judge might say $5,000 personal recognizance. Again, you don't put up any money, but you're promising to be indebted to the state in that amount to ensure your compliance with those conditions. Then there could be surety bail. In Rhode Island, if the judge says $10,000 with surety, it means if you put up 10%, you can get out. Now, if the amount gets much higher, or it's cash bail, then you might hire a bondsman who puts up the money for you. You pay a fee to the bondsman, and then the bondsman signs the forms to get you out of jail. So those are two types of money situations.
So if someone is arrested on misdemeanor, is this, we want to help people, is this necessarily a do-it-yourself thing? I can just wait until they tell me how much money they want and whether or not, since I'm a good citizen, I can be left out on my own personal recognizance. Do I need a lawyer right then, or can I play that out a little bit longer until it comes to trial or whatever else? Do you need a, so
whenever you're charged with a criminal case, you're going to want to have a lawyer.
Right then.
Whether or not you're entitled to a public defender could be an issue, or a private attorney. But certainly having bail set at the beginning is one of the most important things that you can do, because that gives you your liberty. And having bail set, see, it depends on the crime. Some crimes there is a idea that bail should be set, and then there are some crimes where bail isn't going to be set.
And of course, that's what we're going to be talking about soon, because certainly in that case, there were many other, much of a backstory that said maybe he shouldn't have been left out on some of those reasons that you had cited earlier. Since we want to give people information, if you were in Rhode Island and you want more information, ripd.org. And in mass.gov is a way online for you to get some specific information about the parameters as you discussed, if it's under X number of dollars or whatever, what you should do. So a DUI is a misdemeanor, perhaps?
Yes, DUI would be considered a misdemeanor, certainly if it's a first offense.
And if it were not a first, would that affect, either the amount of money that you'd have to post on bail, or would it affect not just the amount of money, but whether or not you're even allowed to be out on bail? Do
Well,
they
again, it
have a
depends.
reason to keep you?
Right, it depends on the nature of the DUI and the crime. If it's a DUI with serious bodily injury or death, you may not be held, you may not get bail, or it'll be a very high bail. And then, of course, conditions, like I was saying, can be set, such as pretrial services in Rhode Island can monitor counseling, and the judge can order you into counseling, or drug screening, or alcohol screenings. Those are types of conditions, non-monetarily related, that can be conditions of your bail. And compliance with those are necessary in order for you not to have the bail revoked.
So while we're going to talk about things like the necessity of bail reform, there are so many conditions about where a bail system is actually punishing people before they've even gone to trial because they are poor, and that certainly doesn't give them as much access to equal protection under the law. Our bail system right now, as it is in Rhode Island or Massachusetts, would you say that it is fair at the moment or in need of being revisited? In other words, if someone is poor, are they really in a distinct disadvantage other than just being poor? They might not be able to be out?
Well, there was, I think, in 1984, a Bail Reform Act federally. And again, part of what you're talking about was considered in going through, is there a disproportion of poor people who can't afford to put up bail being held as opposed to some rich folks who can just say, yeah, you want $1 million, I can post that and get out. So giving the judge discretion on what the conditions of bail should be and the amount of bail is an important thing for the judge to be able to sit and be able to do. And again, looking at all the factors we had talked about, the seriousness of the crime when you get to those capital crimes involving murder and that type of thing, the judge is able to say that I'm going to hold you without bail. And in those circumstances, it doesn't matter how much money you have. So really it comes to play where you have cases that are serious but don't reach the held without bail level, where a judge might look at somebody's circumstances, and if they had no discretion and said, you know, it's $1 million for bail, well, then obviously that is discriminatory against the person who can't afford to put that up as opposed to the person who can. So I think a judge should be allowed to look at the circumstances of each individual as they set bail and take that into consideration as they're going through all of the factors that are necessary, both to ensure that the person attends their court dates and protecting the society.
So I'm sure that everyone should probably agree that the system should never be rigged against the indigent people. It should not.
Right.
But certainly if someone has no money, is in that circumstance, they have nothing to lose, we might think that just by virtue of that they are at risk and we're going to keep them in jail. Is that a legitimate finding? Is that a legitimate reason to keep someone in?
It is legitimate to consider somebody's ties to the community, their job, their employment, their family circumstances, and say that that person is more of a flight risk than somebody who has a good, steady job, family in the community, and other ties to the community that make them less of a flight risk. So oftentimes, when you're going through those circumstances, and this is what I'm saying, give the judge some discretion. If the judge can look at what somebody's ability to put up money is, perhaps if they have a job and they have family and they have all of the other ties to the community that the wealthy person might have, that a reasonably large sum of money, but an affordable sum of money, might be just as much of a hold on somebody as a larger amount for a wealthy person. So I think a judge should be free to look at those circumstances. But the judge should also be able to put these other conditions on it, such as if it's somebody who has a passport that leaves the country often and you're concerned about that, make them turn their passport in. If there's some issue or concern about counseling and drug use or alcohol use, make them do drug screenings and have counseling. And if it's like a domestic assault situation or something like that, give a no-contact order with the victim, which is often very regularly done in those types of cases.
So you're citing some discretion, makes sense, and we're about to get into this case in a second, but one other question. Is there a standard, or is there a list of guidelines that say if you are arrested on DUI or if you're arrested for this or that, that there's parameters for acceptable limits of bail, a high, a low, or something that might be reasonable?
Some states, some federal situations have bail guidelines, and the judge is supposed to follow those bail guidelines. And what I'm just saying, as far as that goes, is the judge should still have discretion. Set standards, set guidelines, that's all fine, as long as the judge still retains discretion to determine whether or not those guidelines should apply to this particular case.
So the story that I cited at the beginning of this segment was taking place in New York. Obviously, it was very tragic, the outcome, that police officer was shot in the head. Mayor de Blasio is now faced with the issue that a judge with New York and in Missouri, and I guess there's another state, the judge does not have discretion when it comes to the potential for dangerousness in the situation. So I guess the first question I want to ask you before we specifically discuss that, when someone's arrested, does that person have his past concealed from the judge who's making that decision? Well, he'd been arrested, say someone had been arrested 7 times before, never convicted, or 1 is pending. Would any of that become immediately available so that they can factor in just how potentially dangerous this person might be?
In Rhode Island, we absolutely do that. A judge will ask at a bail hearing or an arraignment for the history, the criminal history of the person's record. And that is definitely a factor. The crime, as I said at the beginning, that you're being charged with gives very important weight to what the judge might do, and your background, your history. So the protection of the community really is a dangerousness question. If somebody is committed with, or charged with committing a very serious crime, the judge needs to know that. And if they're charged with a fairly serious crime and have a history of that, the judge needs to know that too, because it goes to the propensity of committing these kinds of acts that the judge really needs to know in order to determine whether or not there is a greater need to protect society from this person, even if it's pre-conviction.
So I guess there is much debate about what could be considered nuance. I don't even know if I'd make that judgment call, but when they were saying that this person, the judge had decided that that drug-selling addict should go to rehab, well, sometimes that could actually work, and he could be out and just doing fine and being monitored. I don't know whether or not he was monitored. Certainly that would speak to how potentially dangerous he might be if someone kept an eye on him. But if what had happened in his past didn't come out, namely that he had been arrested several times, not convicted, but had been in rehab and is out on the street, it seems that this would have been very likely a case where this guy could have stayed in jail, not been let out in bail, and of course that police officer would not be 6 feet under, as they say.
Well, again, I don't know this particular facts and what the charges were in the past, but I think a judge really only should consider convictions, not charges, because if you're charged with something and not convicted, then it shouldn't be held against you. However, in going through all of those things, the judge could also have looked at other alternatives, including potentially home confinement, if that was available. And that might have been a compromise between holding somebody in prison without bail or some form of release where they can go to counseling and do the treatment that's necessary, but also be home and confined that way.
So in this particular circumstance of that New York cop having been killed, the drug addict's own lawyer had said that his client had been arrested, not charged, but it was on a violent crime in 2000.
Arrested but not convicted.
Of a violent crime. So not convicted means not convicted. Violent crime, does that give a judge more of an inclination to say, well, between him having a drug issue, which may or may not be fixed, whatever fixed may mean, maybe not using, maybe not selling, but violent crime, and having had several other arrests, doesn't that all add up to, if it walks and quacks like a duck, it could be a duck, we should keep him off the streets until such time?
Well, it's certainly something a judge could consider.
Okay.
And it does factor in, I would think, into the judge's determination of whether or not someone is dangerous. But without the convictions, I would still caution against putting too much weight on that, because if it charges, if someone's not guilty or found to be innocent, how do we hold that against them going forward in the circumstances of a future or a new arrest? But if the new arrest is a serious situation and there are concerns about that, and there are red flags that the judge can see. See, to me, that would be a red flag that the judge should look further into the situation in making a determination of what type of bail to grant.
So this will be an opinion question, David, based on what you've seen, read, or experienced in your practice. Pre-trial detention, it seems that that's not something you wholly advocate, you know, if it's not warranted. But the stories that have come up in the news of late where people have been detained pre-trial because they didn't have money or whatever else. How about the Sandra Bland case I think we talked about a while. Here was one who couldn't make bail, and we know that she ended up dead too, being in the wrong place at the wrong time, namely in prison. So how do you find that pre-trial being detained, is that a problem nationally from what you see? Is that a problem that you think is worth considering, that too many people are kept in jail when they shouldn't be?
I think each case needs to be looked at on a case-by-case basis. Pre-trial detention, that's being held without bail, is absolutely appropriate in some circumstances. I think if you have good judges and they have discretion to look at each case on a case-by-case basis, then the hopefully likelihood of people who are being detained when they might otherwise not be is lessened. But I do think it's a situation that's worthy of research and investigation of. I'm not an expert in what happens around the country in bail setting and what other states use for their factors and that type of thing. But it seems to me that our judges, in Rhode Island at least, really do put a lot of time and effort into determining whether someone should be held without bail or granted bail and what conditions might appropriately be put on that.
Sounds right. Interestingly enough, once we started reading and doing research with this, wasn't it interesting to find out that in San Francisco it has actually been such a problem that it's been elevated to a class action suit against the area because they've had so many people who've been held without bail or couldn't be bailed out because they didn't have the money, didn't have the wherewithal or the means to do that. And then on a different level entirely, young people who had been perhaps a menace, for whatever menace meant, that it had so ruined their lives because just by virtue of them being in prison for a while, pre-trial or whatever, that they turned to hardened criminals, that they couldn't go to school, that they didn't go to school. And I don't know how that works in Rhode Island. You might want to or Massachusetts, how that works, but they're not able to work, they're not able to make money. If it's a young family, they lose houses. So actually, them not making bail in the first place was what started a terrible snowball effect with a terrible outcome.
So where bail is set, and it's a question of the person not being able to make the bail, in other words, come up with the amount of money that's necessary, then I think the courts should review that without holding someone for extended lengths of time, if it's just a question of money, to look for other ways of letting that person out, other conditions they can put on, lowering the amount perhaps to an affordable amount, but making sure that there are conditions to protect society. Because I talked about two issues in setting bail: assuring appearance at court dates and protecting society. But you need to balance the third issue, which is the defendant's personal liberty interests and rights.
And you mentioned, when I asked you whether or not this was a do-it-yourself thing once you're arrested and dealing with bail, you're a lawyer. If you were working with a client, do you have an option, David, to negotiate or discuss on his behalf to maybe change that bail or that restriction upon his release? Do you have any input to that?
Sure.
And how?
Yeah, there's a bail hearing.
Yes.
So after the judge sets bail at an arraignment and you're held without bail, you have a right to have a hearing on your bail. So at a bail hearing, you can either try to negotiate something that works or have a hearing where the judge gets to look at the issue and decide what should be done.
And as a lawyer, you obviously practice in many different areas. Does it matter that you, if you decide to hire a lawyer, that you necessarily work with one who is known to do criminal law versus anything else?
And there are different levels of people who do criminal law. Some lawyers will do criminal law, with the DUIs, the misdemeanors, that type of thing. Others that will do felonies. And so when you're dealing with situations where you have a case that a bail hearing is likely to happen in, meaning that bail is going to be set other than personal recognizance, you want to make sure you have an attorney who's handled bail hearings before.
And also one who's likely to be able to see it through for the rest of the case, whatever that ends up being,
right.
However they dispose or trial or whatever. Do you need to interview, do you have an option to interview lawyers at that point when you're in such a bad place, namely behind bars, waiting to be sprung?
Well, if you are going to hire a private attorney, then you do have family members who can contact attorneys for you, and the attorneys can then come see you and you can talk to them. Public defenders handle these things all the time. So if you're being held, that means you have a right to a public defender, and you'll be able to speak to that person too.
Is there any distinct advantage in having the private lawyer versus a public defender, or can you say in general that public defenders are fairly well equipped to deal with the run-of-the-mill, whatever that might mean for a misdemeanor, for a first-time offender, for example?
I think public defenders are fine attorneys who have handled numbers of cases and handle a lot of cases at one time. And so part of the problem for a person sometimes is that the caseload the public defender has really limits their contact with the attorney and how much time that the attorney has to prepare for that particular case. I think they're good and they can do that, which is why sometimes people want to hire their own private attorney.
Good to know. We hope that this has been helpful to you. Certainly we hope you don't have to be in this particular situation. We assume that this has been helpful, and mass.gov or ripd.org are resources that you might want to consult if you need to, in addition to consulting with a lawyer should you need one. Stay tuned to Law Matters in our next segment, because the law matters to you.